Hi guys, this is Asal. I'm studying for the bar and I wanted to review my notes with you. So today I'm studying evidence and I'm studying the hearsay rules. Before I jump into the rules, I would like to tell you that the hearsay rules are extremely important. They're highly tested on the bar exam and the professors spend the whole semesters teaching just the hearsay rule. So there's no way I can cover this sitting here by the pool chilling. It won't work. I'm going to have to make multiple videos, but what I'm doing now is just giving you a little bit of an introduction of what the hearsay is all about. First thing I'll do is tell you what is hearsay, then I'll talk about rule against hearsay, which are the exemptions and the exceptions, and then I'll talk about a little bit about hearsay within hearsay, but I want to make a separate video just hearsay within hearsay because that's actually very complicated. It's 2 layers of hearsay. And lastly, I'll be talking about the declarant impeachment. So, what is hearsay exactly? Federal Rules of Evidence 802 states that hearsay is not admissible unless any of the following provides otherwise: a federal statute, rules, or other rules prescribed by the Supreme Court. Also, hearsay, the definition of hearsay, it is an out-of-court statement offered to prove the truth of the matter asserted. So you're going to hear this sentence so many times that you're going to have this memorized by the time you get to the bar exam. It's an out-of-court statement offered to prove the truth of the matter asserted. What does this mean? An out-of-court means something, any statement. It could be written, it could be oral, but as long as it is not in court, as long as it is out of court. By that I mean it could be said to the police, it could be said at a hospital, it could be said anywhere, at your own home, in the streets, it could be said anywhere outside the court. And it must be made by the declarant, and it must be made prior to the trial or the hearing. And it must be made and offered for the truth of the matter asserted. Also, there are 2 types of admissible hearsay. There's the hearsay exemptions, which is non-hearsay, and then there's the hearsay exceptions. Remember the 2 types of hearsay. The next thing I'd like to talk about are the 5 steps of hearsay admissibility. The first step is that whether it is out of court. So think to yourself, is it out of court? The next step is to prove the assertion. Okay, is it to prove the assertion? Ask yourself. The third step, you want to look at the non-hearsay exemptions. Non-hearsay exemptions, I'll make a whole video explaining what that is all about. And also the 4th step is the hearsay exceptions, and finally the right to confrontation. And lastly, I would like to go into the rules a little bit, tell you where to find your rules. Here's where you're going to find your rules. Federal Rules of Evidence 801, 802, 803, 804, and 805, and finally 806. And I'll tell you what those rules are about. Rule 801 is the definition of hearsay. So that's where you find the out-of-court statement made to prove the truth of the matter asserted. Secondly, the 802 is rule against hearsay. This is where you find inadmissible unless federal rules. Okay, this is where you find that. And lastly, it is the rule 801, the non-hearsay exemptions, and also rule 803, 804, 807 are the hearsay exceptions. And also you want to look at rule 805, rule 805, this is the hearsay within hearsay. And lastly, you'll be looking at the 6th Amendment, right of confrontation, and Rule 806, the declarant impeachment. So I would actually like to talk about the declarant impeachment a little bit. So what is the declarant impeachment? How does that apply? That applies when there is bias, or when there is the character, opinion, reputation, or specific instances of conviction, when there's a prior inconsistent statement, when there's a contradiction, and also finally the capacity. These are the things you'd be looking at. Lastly, I'm going to finish off this video because I want to make another more serious video for you when I'm upstairs and I'm not by the pool and people aren't walking around. But I would like to actually introduce this book to you. This is Crunch Time. I've introduced this book before, and it gives some exam tips right here. So over here, it states that hearsay typically accounts for 30 to 40% of a typical evidence exam. So remember, it's a big chunk of it. 30 to 40% of your evidence exam is going to be on hearsay. So you need to keep a lookout for the fact pattern that's on hearsay. And also you want to memorize every word of this classic definition. Hearsay is a statement or assertive conduct which is made or occurred out of court and is offered in court to prove the truth of a matter asserted. So in an essay, begin your answer by quoting this verbatim. Exactly. Maybe repeat, put this video on repeat, memorize this and say this exactly. And also you want to look for the statement. Is it oral? Is it written? It does not necessarily need to be testimonial. You want to look at a non-verbal conduct where something is out of court and it's non-verbal, you know, like body language. You want to look at whether it is offered for the truth of a matter asserted. Over here it states that check whether the statement is being offered to prove the truth of a matter asserted therein. If not, the statement is not hearsay. Most frequently tested aspect is this: verbal acts. The statement may be an operative fact that gives rise to a legal consequence. If so, check whether the statement is being offered because of these consequences, not to prove the truth of the matter asserted. And also it gives some examples here, right here. Let me show you. The examples are defamation, breach of contract. You also want to look at the state of mind. Statements which are not offered for their truth, but to show the state of mind either of the declarant or of a listener. Look for the patterns where knowledge, belief, or intent is at issue. And then lastly, you want to look for the state of mind of a criminal defendant, and also you want to look at whether the witness repeats his own out-of-court statements. It says over here, remember that there can be a hearsay even where the witness is testifying to his or her own out-of-court statements. That's where the lawyer objects. I object, Your Honor, okay? And also, as long as the out-of-court statement is being offered for the truth of the matter asserted, the fact that the in-court witness and the out-of-court declarant are the same is irrelevant. So it doesn't matter if they're the same or not. And finally, look at the two steps. Once you've determined that the particular bit of evidence is hearsay, of course, consider whether it's admissible as exceptions, okay? I'll go into it in the next video. But don't skip the first step. So this is very important. I just talked about hearsay. Always remember, hearsay is always inadmissible unless it is made admissible by the FRE. And also remember that evidence that is gathered indirectly from a person not testifying, that's also hearsay. And also last thing, I would like to finish up by giving you a little bit of an example of what is hearsay. Let's say that a person just got stabbed and is about to die, and I'll talk about that later, the dying declarations, but this person says, oh, I was stabbed by the squirrel. Okay, so this I was stabbed by the squirrel is kind of like an out-of-court statement, okay? You want to look at that. And if it's offered to prove that the squirrel had stabbed that person, then that is for the truth of the matter asserted. I think that is the best way you can remember this. So that's pretty much everything I'd like to say about hearsay today. Keep an eye out for my next video. I hope you enjoy it, and good luck studying.